Claims of injustice and or recantations of witnesses or victim statements. These statements, though in a lot of states would be considered, in Georgia in general, these statements are not taken with a lot of weight by the parole board. In a famous case recently with the Troy, person was convicted of murder. Several witnesses recanted their statements, but in the case of the Troy Davis case, they still executed him, though an overwhelming majority of the witnesses to the case stated and affirmed that he did not perpetrate the crime that he was actually convicted of. So given that this famous case is noted that statements of recantation of witnesses, and in cases, there are cases where co-defendants and the victims have recanted their statement, the parole boards have not been uniformly moved to reverse or to grant relief in those cases. In addition, it's become a practice of many of the district attorney offices in cases of rape that they are actually destroying the evidence 10 days after the conviction. That pretty much what puts a nail in the coffin as to those who have been convicted, being able to later acquire the finances to have an analysis done on whatever evidence that exists that needs to be examined under DNA examination. So Georgia pretty much, is very hard and fast in shutting the door on cases. However, there are some exceptions to this somewhat bad news as it relates to the parole board when it comes to considering recantation of statements and evidence that may show that the person who has been incarcerated or convicted is actually innocent. One of the things that can help inmate if he is making a claim of being innocent actually would be better if he had basically unrefutable evidence that makes it crystal clear, unrefutable, that they did not commit a crime. And there are cases where the DNA has been acquired and or some other ballistic tests have been made or offered that shows that the person did not commit this crime, or that the bullet didn't come from his gun if it was a case of a gun. So that does exist. But those are cases where it's not so much of a statement of a person, but actual physical evidence that's been presented that's irrefutable and presented by a professional to the parole board to argue the fact that there's no alternative to them coming to the realization and the conclusion that this person could not have or did not commit the crime. Next, we have the situation where the promises by the lawyers who represented the defendant, that a statement or claim that they were promised parole or promised some type of reprieve for testifying against a co-witness or things of such matter, those are also no guarantees that the person may make parole or should receive some leave because someone broke a promise or the promise was supposed to be held. When a person enters a guilty plea, they enter a plea to the charges, and unless those factors were considered in his sentencing, then disregard any statements as to those promises, because in great likelihood the parole board, they're not going to acknowledge that information being presented. On the other hand, if a person is trying to make parole, one of the better things to do is to submit a solid parole plan. Parole plan includes information as to whether the person is going to make parole, whether or not they have a standing offer for a job, the environment in which they're paroling to, i.e. the neighborhood they're paroling to. In addition, what kind of support system exists for that person? Do they have clergy? Do they have a community? Do they have numerous family members that also support them and assist them? These factors can weigh greatly in terms of assisting a person in making parole. In addition, if a person has registered for college, has taken some classes since he's been in prison, taking several classes while doing his time, the person is enrolled and working towards improving themselves. These factors are very considerable factors in terms of them making parole. For further information, contact us at theparoleadvocates@gmail.com. Thank you.